If a judgment is a court order, why can't the court just automatically make the debtor pay us? Attorney Art Matthews explains, hundreds of years ago, debtors were actually imprisoned for non-payment of debts until they or their families paid up. However, it doesn't work that way anymore. In California, the enforcement of judgments law provides creditors with many different tools for collecting judgments. The only time someone may possibly be threatened with prison or held in contempt is if they fail to obey a court order, but failing to pay a judgment by itself is not grounds for that. If we were to serve a debtor with an order to appear in court for a post-judgment examination and they fail to do so, then the court can issue a warrant for their arrest. Oftentimes, debtors don't appear because they don't see the importance of appearing or just choose to ignore the order. While failing to appear could result in a finding of contempt, and a finding of contempt could result in prison time, this rarely happens. With that said, the threat of a contempt order arrest warrant is oftentimes enough to get a debtor to speak with us and agree to a payment plan. Ultimately, the courts can't be relied upon to collect for a creditor. The creditor has to go out and do it themselves, which is why it is so important to have an experienced attorney who can ensure the greatest likelihood of success. Most people don't have knowledge of the enforcement of judgments law and don't know which tools are available to them. It's a difficult process to navigate, and frankly, there are even attorneys who are very good at what they do, but do not have experience in collecting judgments. It's a unique and important skill to be able to collect on a judgment. Matthews Law Firm's primary goal is to provide high-quality legal service for a fair and reasonable price. We welcome any opportunity to help clients fight for their corporate rights.